Hello, lovies. How are we? Can you hear me? Because I put a post-it on my desktop that says, "Can the lovies hear you?" Hey, Jen Murphy. Yes. Oh, Jen Altman's in the chat. That's fun. How are we? Well, it's been quite a week, hasn't it? A week, a whole week that feels see, the month of January, babes, is always a month that I love because I'm a Capricorn. I was born January 12th, and it is the longest month, like, in every year. It just makes you feel like, how is it possible? It is day 625 of January. And this last week felt like 6 months, okay, combined. Emotionally charged. Was it a full moon? Who am I? I don't know. But we are back today on January 31st, 2025. Happy Friday. And we had quite a hearing in Commonwealth V Karen Read. I was ready to rock. I was ready to roll. And I am feeling quite froggy and loving Mr. Alessi. If I didn't love him before, today, babes, he sold me, okay? He sold me, he won me. I I was ready to have my popcorn and just watch him take it take it all the way, okay? And make Hank Brennan so flustered that he went through at least a dozen number twos. Look at those pencils. Tonight's episode is brought to you by the number two, okay? By the number two pencils that good old Hank Brennan was fumbling, just fumbling those pencils. Okay. Oh, look at. So let me say hi to you. Hi, everybody. Hi. We've got Cindy B. He's a beast. Yeah, he is. Ooh, Trident. You're a Capricorn as well. January 6th, little Christmas. Happy belated, lovey. Oh, and don't get brazen with me, says he's such a great addition to the team and he was sorely needed. You know what I love about Robert Alessi is that he kind of combines the best of, in my opinion, Mr. David Yannetti. Still would like to be your intern, sir. Call me. um, he has he has a charisma and a likability about him, but he also is an assassin. And when I tell you how impressed I am by his ability to pivot, today, ladies and gentlemen, I clutched my pearls, I clenched my butt, and I was ready to rock and roll. How quick he was able to pivot, change his argument, knows everything. He is like a walking filing cabinet to me, right? Like he has all of it there and he's ready to access it at any point. I love that. I get a little bricked up, I'm like, hey, what are we doing? So he was incredible. And yes, absolutely. Trident says assassin. Tracy V, he's a badass. He's a good ass to me, and I love it. So, what I wanted to go over with us, guys, was in the beginning, they talked about Gretchen Voss. The Boston Magazine attorney got up and he did his thing. That poor man, every time he comes to court, looks as though he combed his hair with a pork chop, and we love him for it. You know what I mean? Like a little bit of an old disheveled, a nice man, right? I feel like his office has a lot of papers, right? And he just fumbles through those papers and he thinks to himself, Is this the right file? Am I in the right file right now? And then he has to call up to the front. He goes, Sheila, where am I going today? He has no idea, right? Then he just takes that pork chop, does a little a zoop zoop in that part, and he's ready to go. So they argued about the Gretchen Voss notes and the off the record information that she had potentially provided and written. Now, there was a request for this not to have to, there was a request for reconsideration, if you will. And I got to tell you, I wanted it. Now, you're going to say, Kim, are you crazy? We don't want to see the handwritten notes of off the record information from Gretchen Voss. Yeah, I do. Yeah, I do. And you say, Kim, why? Oh my gosh, that's so weird. You're a weirdo. I want to know because I think that Gretchen's notes would have shown her true opinion of Karen Read. And not meaning anything case related, but like, did she write snarky, maybe things down? Like, hate your shoes. Think you're a bitch. You're a skinny little bitch, and I don't like you. I don't know if she wrote that. I'm just saying. But what does a journalist, what would you be writing down that wouldn't be case related, right? And you're off the record stuff and her work notes and her progress that she is able to do, there is going to be things that she's making just observations and opinions on. And I have a feeling, now don't, hold me to it because we'll never know. But I feel like Gretchen Voss may be a mean girl. Heard it here first, maybe second, possibly third. But I don't think that she had anything nice to say about Karen Read. And I don't think that any of her, her work notes would have shown kindness at all towards her. And that she was a little bit of a Slytherin snake with how she got in and how she ended up changing what they thought the article would look like to what it ended up being that came out of Boston Magazine. So, it was decided that Judge Cannoni said, well, I'm going to review everything in camera and we'll figure out if I'm going to let it in. Well, a ruling came out at 7:00 tonight, guys, and let's go over it because the motion to reconsider has been approved by Judge Cannoni. Breaking news, 7 p.m. Voss ruling. Oh, we can't read that. Winning. Oh, please. I have to get it from X. Sorry, babes. We'll hide that. And I will pull it right up on my phone and we will just read the end of it. Together forever. So it says new memorandum of decision and order in non-party Gretchen Voss's motion for reconsideration of December 5th, 2024 court order regarding the records disclosure that the court is allowing Voss's motion and will not require the disclosure of her handwritten notes from the July 7th, 2023 off the record interview. So for that one specifically, and I think there was one other, hold on. We know that, was there one more? I feel like she had two. Oh, no, she did. No, it was two on the records, one off the record. So this was the note from, okay. So this was from just the July 2023, 7/7/2023. But that's a big deal. It's also a big deal, guys, that we have Judge Cannoni, who is infamous for taking her time. She rules nothing from the bench. We know this. But babes, today she's throwing out multiple. She did the order for Gretchen Voss, and then she also provided a order kind of that she will not be requiring a hearing for Richard Green. But we're going to listen to what she said at the end of this hearing today, and we're going to know which way she's going, because there's no way she's not allowing him to testify. You're not disqualifying this expert, and especially not after Alessi Slasson. I don't know. We're going to figure out a name for him, but we're going to get it working. We're going to be cooking with gas, if you will. And she is going to allow him in. And I'm very interested to see what her ruling and the order does look like. All right. So that was that. Then the next part was the ARCA, our guys, our crash daddies, and said that ARCA was unable to provide the discovery that was requested by the Commonwealth and by Hank, because fucking God, Hank just wants it all. Hank wants shit that the defense didn't get, that no one got, because this all happened from the federal investigation into the investigation of Commonwealth V Karen Read. And the PhD ARCA crash daddies were able to conclude that Officer John O'Keefe was not struck by Karen Read's Lexus vehicle at 24.2 miles per hour, causing his fatal injuries and ultimate death on January 29th, 2022. And so Hank Brennan sets out this list of demands. He's like, bitch, I want to know, what was a dog in Canton that lived down the street? How was his bowel movement on the morning of January 29th? And you go, I'm sorry, I didn't even know that, Richard and Patricia had a dog. Okay. How the Christ am I going to give you that information? And he's like, just asking for things that nobody received, and yet they were still able to very confidently express their expert opinion on this case and how it would not make sense. You cannot fit the square peg into this round hole. And they just moved forward. Judge Cannoni said, hey, boo, do you have anything you want to say to this, to Hank Brennan? And he clutched his pencils. He grabbed 4 pencils and he said, no, Judge Cannoni, I'm okay. I'm okay with whatever you say. Okay, no, you say goodbye. Okay, so that's what they were doing. They were just bantering with one another. And then we got into the main event. Now, this was to me a Super Bowl, if you will, of pre-trial hearings that I've seen thus far. Hank Brennan comes out the gate. He is swinging. And then Robert Alessi hits him with the haymaker at the end. So let's get into it and let's watch together. And then we will, just talk about our feelings. But a great day. I feel very confident in everything that happened today. And I feel confident in the rulings in favor of Karen. And again, poor Hank's just not getting any wins in his column, if you ask me.
Go about it.
Will be my fault.
All right. So if you can work on that, I'd appreciate that.
Yep.
So I will take the lead from the two of you on that.
Thank you.
Okay. All right. So this brings us to the Commonwealth's motion
Oh.
to exclude defense witness Richard Green's debunked opinions. So I have received a great deal of pleading on this. So the Commonwealth's motion, and there was a affidavit attached, a report attached from Mr. Whiffen. The defense has filed an opposition, an affidavit from Mr. Green, and then another affidavit from Mr. Green that doesn't, they're two separate affidavits. And the affidavits are clearly different in substance. So I'm a little, I don't know what you want me to think about that. But Why don't we hear the Commonwealth on its motion first?
Button up, Hank.
May it please the court, we filed a motion to exclude Mr. Green as a witness regarding 2 points. The first is a claim that a witness's phone made a search for a phrase to the effect of how long to die in a cold at 2:27 a.m. And secondly, to exclude an opinion that there was some type of intentional deletion of that entry. This case, I propose on behalf of the Commonwealth, is appropriate for a Lanigan hearing. At that Lanigan hearing, I suggest that Mr. Green should testify and answer questions about his affidavit and his opinions that he would like to subject the jury to. In fairness, the government would call an expert as well. If this case, as the court proposed, potentially scheduled for next week, Mr. Whiffen would not be available, but Ms. Hyde would be available, and I would call her as a witness. Mr. Whiffen, if necessary, is available later in the month as a witness. My suggestion is there should be 2 witnesses, Mr. Green and 1 witness from the Commonwealth. The Commonwealth witness will be able to explain the science, the data, forensic science, and methodology. And Mr. Green, I suspect, should be in a position to explain his ultimate opinions because what we see in his affidavit is an absence of methodology. Mr. Green has filed 2 affidavits in this case. They are very similar, but there are very
Okay, so now I just wanted to, sorry guys, I know I'm so sorry. I'm going to try to do this I'll do it on 1.5, and I'm so sorry about the quality as well. But let's go into this first and foremost. His entire argument about Richard Green is the same exact argument that he had for our queen, Marie Russell, Dr. Marie Russell. He's talking about methodology. He's talking about her, the opinion, the expertise. I mean, it is like I'm having deja vu, okay, hearing him talk and thinking that now we're talking about a digital forensics expert, not a medical opinion. And yet he's using the exact same terminology and he's fighting the exact same battle as if the experts in any case have 100% factual evidence. He's arguing as if the Commonwealth of Massachusetts is fact. And sorry, babe, that's not how this works, Hank. And for let's keep it a buck, my guy. The Commonwealth hasn't been correct since day one of the investigation into the death of Officer John O'Keefe. Never mind what has gone on in pretrial, before trial 1, during the trial, and now into pretrial for 2.0. So, your righteousness is not being well received by most.
very significant changes to those affidavits. And it stands out as very interesting, the changes to the affidavits when I look at them. On number 3, he changes his characterization of what his profession is. He originally calls himself a forensic technician, and then the updated affidavit cites that he's a computer network technician. Now, that is odd because usually a professional knows what they do for a profession. Simple explanation of what he does stands out.
Are you kidding me? Ouch. Coming out swinging, good sir. Why are you fighting so much? Like, why are you fighting so hard for every single witness? And I get it. I get that Lally wasted all of his time, or allegedly, by trying to disprove a third-party culprit in the first trial. I understand that. But everything you touch, Hank, has turned to shit as it relates to a win for the Commonwealth. And you're saying that Rick Green doesn't know what he does for a job when he just told you. You're a judgy bitch.
Also stands out when using technical terms. They either were wrong or changed from the first affidavit to the second affidavit. For example, number 9. He talks about the download as a full file system extraction, then changed to an Apple iOS full file system. My point is, that when you look, this isn't simply misspellings or poor grammar. There are terms of art that are wrong between the affidavits or changed. When you're using the terminology of a item that is a forensic tool, such as gray key, it is spelled wrong throughout the affidavit. And so it seems to me that Mr. Green's affidavit had some assistance in building it.
Oop, okay. And here is where you stepped out of bounds. Here is where we had some unnecessary roughness on the field. And you, I mean, just Hank, Jesus, Mary, and Joseph, okay, all of them. How are you going to talk about errors and spelling errors? Because every one of your motions has had errors in it, including, but not limited to, requesting phone records from Mr. Read from the year of our Lord 2002. That's a pretty big transcription error and Scribner's error. So that's the pot calling the kettle black. And then alleging that he got like assistance from the defense by writing his papers for him. You're doing what you did exactly. We've seen this. I've seen this film before, and I did like the ending. As when it came to our Dr. Marie Russell, you said that the Commonwealth, has questions about how she wrote her report. And then you're alleging that the defense did it for her. Nobody's doing people's homework for them, my friend.
And the tone of the affidavit supports that thought. When we look at Mr. Green's affidavit, it is not that of a forensic examiner, it's that of an advocate for the defense. When we look at his affidavit, there is quite a bit of advocacy, insinuations and surmise and conjecture and claims that have no factual basis, but there is little on methodology. In ways, it is a very dangerous affidavit to simply make assaultive comments that a user did something, purposely deleted her important phrase, how long did I die in the cold, without any forensic data or evaluation or validation. Similarly, when we look at his affidavit, it is replete with accusations suggesting but never proving, never providing fact, that there was some type of manipulation or tampering with evidence. Now, this is not the role of a forensic examiner unless there is proof, in fact, that happened. But when we look through his entire affidavit, we don't see any attachment of raw data. We don't see an updated report. We don't see any viable information that in any way supports his speculative accusations. And so the defense, without having opportunities to Green prior to trial, stand behind these statements under oath, would like him simply to come before the jury, make these salacious comments, and then leave it to the government to knock it down. And
for the big bad government to come and knock it down, because Hank huffs and he puffs and he blows your house down, babes. Don't you know? Okay. And poor little Richard Green, he's just a little piggy in the house. I don't think so. Okay. I don't think so. He doesn't live in a straw house. Doesn't even live in a wood house. He's got that brick, baby. And he's not afraid. And he's not afraid because there are very considerable facts. Facts matter journalism. Facts matter experts, okay? That Robert Alessi tells us, and he's like, yeah, except they did find this. And except that's real whack because we know only one record was deleted out of all of the records of the entire phone. Oh, I have a little something for us. Maybe we could. Oh, I think it'll apply to this, babes. Ready? On your mark, get set.
Suspicious, don't be suspicious.
Sean Ralphio?
that might be a common view in the transcripts of this case, but the Commonwealth does not intend to simply let evidence come in that's not qualified, that's not factually sound, and then go knock down glass houses. That is not the approach the government is going to take to this case. Mr. Green is going to testify. He should have a report that is factually based with methodology supporting these claims, these narratives that he's proposing. Considering testing in this case, there are certain tools that are used. The defense wants to propose that there's some type of race that Mr. Green looked at or used more tools than a Commonwealth expert. The tool is simply software, a good analogy is that of an X-ray. Anybody can take an X-ray, but it takes an expert then to interpret the X-ray, to interpret the data. In this case, Mr. Green in his affidavit proposes that because he used a number of tools, because he has a number of X-rays, that somehow there's significance to it. But what it lacks is a forensic analysis of that information. And it is clear in his affidavit that it lacks that. He cites two opinions. His first opinion is based on Cellbrite processing and Axiom processing. I'm not going to go through all the little details that we dispute or go through a technical assault on each point, although that the overall idea of this evidence is why this should be subject to a Lanigan hearing and why we are willing to call our own expert as well, so that the record is clear and the science and data is clear.
He says, I'm not going to assault you. Just kidding. Yes, I am.
Instead of doing validation or testing, relying on Cellbrite, what Mr. Green has done in section number 13 of his affidavit is step aside from methodology.
I also wanted to just take a minute real quick, guys. Look who's behind. Oh my gosh. Do we see our Esty? Hi, Esty. And hi, Mr. Reed. I was distracted by her beauty.
And instead, he cites that he called Cellbrite technical service. Now, this is the forensic examiner who's supposed to go through the process, and yet he defers it to technical support of Cellbrite. Technical support of Cellbrite, he relies on to say that this artifact, where this search is stored, is appropriate.
Bitch, did you just say he called customer support? How rude.
And he remains standing on that foundation as why somehow there's some validation that this search occurred at 227. But then when he learns that Cellbrite, after actually doing analysis and study and updates and engage in methodology and review, determined that the way that was assessed is unreliable and the program has been updated, which no longer shows the 227 search at 227, and I'll explain why for good reason. I'm sure the court has heard this before. Mr. Green then denounces the very source he relies on. And so on one hand, he's saying, I relied on technical assistance to Cellbrite, but then when they told me what I didn't like, I can ignore that part. He then refers to Axiom. Axiom, the government.
The shade. When they told me something I didn't like, then I went to Axiom, which is whose baby is Axiom? Mr. Whiff. Whiff it. Whiff it, whiff it.
Defense house is a separate source that reinforces the same point when clearly it doesn't. You can see in number 14 of Mr. Green's affidavit, he talks about the fact he uses these different programs because he wants to view data. That gets back to the X-ray analogy. He is viewing data from many different programs to say the same thing, but he never goes on to analyze it. What is troublesome about his affidavit in section 14 is he attempts to use resource material to convince this court that rather than methodology, these summary statements are something that the court should rely on. And so what he does is he takes an excerpt, page 7 of his affidavit, number 14, and he says that he
Whiff it.
Axiom user manual.
Whiff
describing
it
the artifact
real
as follows.
good.
The artifact is in Safari suspended state tabs, and then has the last interaction date time.
Mer,
And the
mer.
date and time of the current tab state when it was last interacted with on the local device.
All right, this isn't. Let's get over this.
Manual. You don't have to
He
you
says,
use that to buttress
pull up, bitch, bang, bang. Okay. And now let's keep going.
them or makes mention of them in his report, and yet he does nothing as far as validation
Ooh.
to consider the arguments and dispel them. He does nothing in his affidavit to address the methodology. Quite to the contrary, when you see
He does nothing to fight back against the Commonwealth's experts and do exactly what he is supposed to do while he testifies at trial. But he didn't put that in his report. Oh, Hank. Oh, this is looking pretty desperate, housewife of you. Are you a real house husband? What are we doing, hon?
Mr. Whiffen and Ms. Hyde's reports, it isn't baseless opinions and advocacy of a side. When you look at their report, it is replete with methodology, fact-based, information-based, the study of the particular device at hand. The contrast between the actual use of methodology that is reflected in Ms. Hyde and Mr. Whiffen's report and this affidavit is so clear. Now, there are two opinions that are proposed pursuant to this affidavit. The first is the claim that how long to die in the cold was somehow inputted at 227.
It was.
The only effort that appears in this affidavit by Mr. Green is in section 15, where he did a low-level analysis of the wall file. Now, I am not an expert, and that's why the court should hear from Ms. Hyde or Mr. Whiffen and Mr. Green. But a simple understanding.
Oh, okay. So I just want to remind you guys that while he gaslights us, okay, like a real abusive I don't know, like a coworker, boyfriend, I don't know. He's like, "You are not an expert. You are not an expert. You suck at life." And then he's like, "Why don't you go ask an expert?" And you are one of them. You just named Ian Whiffen, Jessica Hyde, and Mr. Green while fighting to say he is not an expert that could determine if this 227 search occurred. Also, I do want to tell you that I watched Emily D. Baker for a while today, which was incredible. I love Emily D. Baker. And she was it it chapped her ass as an attorney so much that Judge Cannoni read from the bench the name of this motion for the debunked. Like, that is so egregious to her. She's like, she didn't even like to hear Judge Cannoni say that from the bench because that's not her opinion. And the title was like offensive to anybody who is like a legal expert. It made them cringe.
Wall file can contain information in the repository.
Okay, well, you know who does know? You know who does know all about it?
Look at the
It's Robert.
non-binding factors of land. We look at number one, whether
The
it's
assassin.
been generally accepted in the scientific community. The software has been generally accepted in the scientific
Oh,
community.
generally. Yeah.
So hasn't the effort of a forensic examiner, the expertise. And the defense complains in the motion the Commonwealth has not properly addressed the methodology of Mr. Green. Well, the reason why is Mr. Green does not provide any methodology. So this is the way to address the methodology. Number two, the opinions have been.
Kelly, ain't that some shit, right? When you're looking at Richard Green's new affidavit that he provides, and you see that he not only doubles down on this, but he's like, I can pinpoint it to, I don't know, I don't know, what is that? The hundredth, thousandth place? Wait, tenths, hundredths, thousandths? A second to the like 100,000s. No, the thousands. No, hundredths. I don't know. Okay, I'm not a time. All right, I'm not a time traveler. But what I'm going to tell you is this: that's a lot. Okay, that is so pinpointed that it leads me to believe that when we hear from the Commonwealth's experts at trial, that they're going to be singing a much different tune than their holier than thou, very, very firm and factual, and a mother knows best. That was Mrs. Hyde.
Or can be subjected to testing. Well, we see Ms. Hyde and Mr. Whiffen's report directly contradict the assertions, the unsupported assertions of Mr. Green. There is no testing that his opinions have been subjected to. There is no peer review. There's no other alternative support.
Clay's nanny, can you do me one solid, babe? Can you just update your nanny part and make it like capital NAN for attorney Nan Gallagher, who kicked ass and took names, girl power over on the Young Jerks? Those opinions, I clutched my pearls. I was so excited. I'm sliding into her DMs to see if she ever wants to, I don't know, hang out. She said she would. So maybe next week after one of the hearings, because we have court on Thursday and Friday, maybe I could get attorney Nan, Clay's nanny, only Nan. So much we can work with her.
First opinions, they're just broad, baseless claims. Number three, has been subjected to peer review and publication. Certainly the science, the forensic science has, the software has, but the interpretation and Mr. Green's interpretations, it hasn't been subjected to anything. In fact, it changes. It has an unacceptably high known potential rate of error. What we see in read Ms. Hyde, it's just a high level of error. It's gross error. It's total error. It's wrong. And is governed by recognized standards.
You're
So,
gross.
if you look at the history report that the defense filed as an attachment, it talks about a forensic examiner's obligations to verify, to test.
Which he
Mr. Green
did.
didn't do. Their own report that they offer in support undermines the idea that Mr. Green did anything to validate or support his opinion. And as we see from both Selbright, he does not follow the protocol. He does not follow Axiom. for the guidance that they give him.
Yes, he
sidesteps
does.
both of them to give the opinion he wanted to advocate for the defense.
Oh God. And listen, like, I'm not to be a bitch, but like, remember when we would always say, like, Hank, have you done your summer reading, babe? Like, have you done your summer reading? Did you watch trial 1 yet? I don't know if Hank has not done his summer reading or if Hank does any reading. Okay. I question sometimes, Hank, babe, I feel like his paralegal is making that 75K, she's working hard. And he's just sitting there organizing pencils, just one number 2 at a time, right? Putting them, lining them up, making them into little housing pyramids. Friggin' oddball.
At every turn, positions of Mr. Green are not only unsupported, they're unverified. So
Not
what arises
true.
from the subterfuge is that Mr. Green is really just a vessel, or an attempted vessel, for defense, third-party public defense. It is not lost on me.
Oh. And this was the moment we all said that's assault. Okay. We became Grant Smith Ellis outside of Norfolk Superior. And when Hank Brennan said that Richard Green is a vessel, he is a vessel for the third party culprit defense of Karen Read. And we said, oh, I found something for you. I found something for you, Hank. Oh, it was just right in my pocket. Look. Fuck your pencils.
I'm not unmindful of the date on the phone being a search hotline dial call that occurred at 6 a.m. in that morning coincides with first responders' testimony that the defendant herself was asking these very same questions around that time about Mr. O'Keefe and how long he was hold. Under the extraordinary broadness of circumstances and the depth of the amount of witnesses and information in this case, it is hard to think that just happened by happenstance. That there is a inquiry, something forming in the mind of the accused is then shared with the witness, Ms. McCabe. And in response, she makes the search, which is entirely supported by all the credible forensic evidence.
No.
Green is going to be witness in front of the jury, like the fact that he has no methodology and he's wrong on.
So okay. So it was done after Karen had asked Jen, was that before or after they were praying in the back of the cruiser? Was it before or after Officer John O'Keefe had already been transported to Good Samaritan? Was it before or after Jennifer McCabe had made a 911 call, but also had contacted her sister? Like, Hank, you're very, very convinced, which I get it. Like, listen, you're a defense attorney and you're defending your client. You really are. But this isn't a good look. You're making me wish we had Lally.
Science. In addition to the fact that he wants to now appear as advocate for the defense and accuse everybody and anybody without articulating who, just anybody other than the defense.
Cool.
He should have to stand behind those claims under oath. So I'm asking for a Lanigan hearing. We are not shying from our burden. We're more than happy to bring in a witness so the court can contrast the two. Thank you.
All right, thank you. Mr. Alessi?
Look at this. Gear up, babes. Giddy up. Look at him. Look at his little curls. I love it. Bring me to 87.
May it please the court.
Yes.
Mr. Green is eminently qualified to provide testimony in this case with regard to the subject matter that has been challenged by the prosecution in this case, and that is with regards to the search of House Long to Die in the Cold that
Obsessed.
occurred at 2:27:40 a.m. on January 29th, 2022. Mr. Green, and I want to cover the baseline for this hearing first. Mr. Green testified at the first trial. He testified without objections as to his qualifications. He testified without objections to his methodology. Your Honor sat, obviously presided over that trial. Your Honor did not issue after his testimony any limiting or curative instructions with regard to either his qualifications or methodology, nor did the prosecution after his testimony stand up and ask for any such limitations or qualification. The baseline for his qualifications and methodology.
Can I just take 1 second and look at Mr. Read? Like, intently listening to Mr. Alessi and just saying, like, he's like, get him, get him. He's leaning forward. That body language says it all. We all did the same thing, Mr. Reed.
Was established, again, without objection. And
Phone. Oops.
But they are being challenged now.
I was just waiting, Your Honor. They are being challenged now, but the reason I state that is because what Mr. Green has provided in response to this motion is even more detail than what happened in the first trial. In Mr. Brennan's argument, he did not make one argument about Mr. Green's qualifications.
Mm-hmm.
Zero. So I'm assuming, because there's nothing in their motion that even goes into why he might not be qualified. So to me, Your Honor, that's a tacit concession, if not expressed, that he's qualified. And of course, he has to be qualified in digital forensics because there are 5 other areas of digital forensics opinions and methodology that Mr. Green is testifying about that has not been challenged. So to me, it is rather odd right off the jump that there's no challenge to 5 other areas of data forensics, and there's just this challenge to one aspect of this whole testimony and opinions. I have provided Your Honor with 2 exhibits, demonstrative in support of my oral argument. Exhibit 1 is entitled Digital Forensics Methodology Regarding Subject Artifact, and Exhibit 2 is entitled Digital Forensic Product Tools Used by Witnesses. The Commonwealth has agreed to my use of those exhibits. They had some, I agreed to theirs. And I would like to, Your Honor, use
compromising.
The Commonwealth, in its oral argument, said 10 times just now
10
that
times.
there's no methodology and that Mr. Green does not articulate a methodology.
Get him.
That is incredible to me because the opposition and Mr. Green's affidavit, in fact, are replete with the methodology. And here is the key, Your Honor. While Mr. Brennan challenges the methodology, none of his witnesses, neither Mr. Whiffen nor Ms. Hyde, challenge the methodology. As a matter of fact, in their 2 reports, neither of them even describe Mr. Green's methodology, nor do they challenge it. And of course they can't, because it's the same exact methodology that they use. And that's what I would like to go to now. Exhibit 1 is entitled Digital Forensics Methodology Regarding Subject Artifact, J. McCabe iPhone Data. And I prepared this. This is just what's in our opposition. It's in Mr. Green's affidavit, but it summarizes what the methodology is that we're talking about here. What is that methodology? Step 1, you receive, and this is to answer the question about what is the proper interpretation of the artifact in question that everybody agrees is the artifact. Step 1, receive a full file system image of extracted data from the Commonwealth. For example, the defense received it on a USB thumb drive. That's undisputed. If you look at the reports of Ms. Hyde, you look at the reports of Mr. Whiffen, they all say they received a full file system image of extracted data. So step 1 in the methodology that everybody agrees to, everybody agrees that occurred. Number 2, verify hash signature value of.
Okay, so here's our methodology. 1, everyone did the same first step. Step 2, hashtag JK, hash signature.
Image file of data received. This is very important because
Wicked.
hash values with regard to forensic data is extraordinarily important for it to be proper because it's the signature, the fingerprint that allows data forensic examiners to be sure that the data that they're giving is sacrosanct. It is not possible for manipulation. The Commonwealth just said that Mr. Green has hurled several accusations without a basis, one of which regards the potential for manipulation of data. And it's remarkable that there is even an issue about this dispute. Mr. Green did put in his affidavit an unprecedented situation, and it is this. Mr. Garino, Trooper Garino, in his April 2023 report, which is an exhibit to our opposition, states that when he got the phone of Ms. McCabe, he used Celebrite UFED, a tool of Celebrite, to image the phone.
Okay, babes. Now, if you are like thinking to yourselves, shit, this volume sucks, and I know he's talking a lot of IT jazz, and I like his passion, but I'm kind of fucking lost. Just bear with us because we're about to go to another galaxy together. Because the assassin is going to take him out. Ready? Listen.
And that's all he said to the defense in the beginning. Why is that unusual? Because what happens in every case, without exception, is that the law enforcement sends the raw image original data that has the hash signature on it. And the hash signature is an algorithm that produces, they call it in this case, SHA-256. What it is it's a stamp of reliability that says, as soon as we got this data, we immediately processed it the proper way and put a hash signature so that there can be no contest. What the Commonwealth fails to tell the court, Your Honor, is and that leads any proper data forensic investigator to question the integrity of the data. If you turn to, Your Honor, Mr. Whiffin's very long December 2024 report, which is Exhibit 1.
Very long.
The Commonwealth's motion on page 3.
Then what
And I'm
happened?
going to read it verbatim. This value is talking.
Oh, I promise it's not me, guys.
Point. However, this requires authentication of the original hash value, which is not possible with gray key extractions, as the PDF containing the extraction hash value is unsigned.
What?
Therefore,
What?
this hash value could be used as a suggestion of authentication.
Okay. Okay. So I just want you all to know, I want you to clutch your pearls. Put them on, Mimi. I've got mine. Gear up, babes. Okay, so we have a suggestion. We have nothing that is an actual signature. There is a suggestion. This is done by Guarino. And then what happens?
That's all a fancy camouflage way of saying, Mr. Whiffen saying, I can't validate this hash value because of the way Trooper Guarino processed it. Do it, Mr. Guarino, Trooper Guarino, the right way when he got it. And why is this of concern? Add to this point that's conceding that the hash value in this data cannot be validated. How did the defense get this? When Mr. Guarino used the Celebrate UFED reader, all he turned over in the beginning was the UFED reader report. He didn't turn over the data. So Mr. Green had to ask for the data. Then what happens, misstep number 2, Trooper Guarino only provides a PDF of the hash value. He used gray key, which was a mistake because gray.
Bitch, I don't know the difference between a PDF. I can't even get like things to convert in my StreamYard from a movie to an MP4 or a 3 or an MP4. I don't know what it is, but I know damn right well that these people who are supposed to be your forensic geek squad, okay? They're supposed to best buy this shit and we're supposed to be able to trust it, right? Well, looks like there has been fuckery afoot.
Gray key, you can't get the original hash value. Mr. Green had to go back a second time and say, no, we don't want just a PDF. We want the full extraction. Yeah. Finally, after the second time, the defense got the full extraction. And that's when we discovered that the validation was improper. It's not Mr. Green.
And you know what that calls for. You know the only thing that makes sense.
John Ralphio?
Yup. Okay.
Coming up out of thin air with these issues, this is the job of a data forensic person. And the first principle is to see whether the data is valid. So not only does Mr. Green justify in his affidavit why there's a big concern over this, Mr. Whiffen concedes it on page 3 of this report. That starts, and I'm going to get to it, all the concerns now about the data and deletions. But that's the foundation for it, and it wasn't caused by the defense. It was caused by Guarino, who didn't do this properly. And with regard to the methodology, I want to go back to Exhibit 1. So, importantly, Your Honor, 1 through 4 of this methodology is undisputed by all of the data forensic persons. Mr. Whiffen, Ms. Hyde, and Mr. Bean all agree on 1 through 4. They all agree that this is the methodology. Number 2.
Just wanted to take a minute, guys, and remind us all that today, single-handedly, the assassin asked himself, is this going to free Karen Read? And babes, guess what the answer was? Fuck yeah.
3, once you get the image of the file, each examiner saves the image to their lab storage system. Some use computer servers, some cloud storage. And 4, the methodology, you then process the data with appropriate tools. Nobody disputes that Celebrite Physical Analyzer and Magnet Forensic Axiom are 2 of the many tools that are available to use. There's a dotted line that I put there, Your Honor, because 1 through 4 is undisputed by all 3 data forensic examiners. Number 5. And 1 through 4 is usually all one needs to do as a data forensic examiner. But Mr. Green went on to do more. Number 5, further processing of data as warranted, and he explains why it's warranted here with additional tools. So he then went on to use Sanderson Forensic Browser, ArtX, Belkasoft X, and then
Oh, okay. So he went to go ask the Sanderson sisters. He asked Baltazar. He asked Artie, the one-man party. He asked every fucking buddy. And what did it come back?
he didn't use iLeap. Miss Hyde used iLeap. So it's important to line up the methodology. I just don't understand how it can be stated that there's no methodology stated. Not only does Mr. Green state it, we prove undisputed that everybody agrees this is what the methodology is. And that is what is so flummoxing as to why we're even here, because the methodology is agreed upon. What is disputed, Your Honor, is what are the opinions from when you apply the methodology and you apply these tools. So interestingly, it is Mr. Whiffen who provided the most lengthy report in this motion. Mr. Whiffen only used 2 forensic tools. He only used Celebrite Physical Analyzer and his own software, ArtX. That's it. What I'd like to
Okay, so I just wanted to ask you guys, right? Like, so we're sitting here and we know that Miss Hyde, she used 1, and she was like, "No, I wasn't able to look at that." I remember her testimony, her being like, "No, I didn't look at that. Mine was my scope was very limited to scoop, but it beep ba ba." Right? And then we know that Ian Whiffen was like, "Yes, please download my subscription, like and subscribe to Artie, the one man party." Right? That was fucking Ian. And then we know that Mr. Green, and here's another thing about Mr. Green. God bless that man for getting on the stand, getting yelled at, and feeling his feelings and being such like a kind man that he was like, "I'm so sorry that I've made you upset. I didn't mean to make you upset, but like I this is not what I meant by that." But all of his information was 100% the same. If you say you are sorry on the stand, and listen, I've learned this lesson from Richard Green, they will take it as weakness. The Commonwealth will take it as weakness and then pretend like everything you wrote was a mistake, even though he used what? Celebrite, which is the #1 forensic motherfucker that puts away our what are they, perpetrators every single day in the United States of America. Celebrite is the gold standard. But then you're telling me that Richard Green also used the Sanderson sisters, Artie the one man party, and Baltazar? Fuck off. He's used more shit than all of you combined and still figured out to the 227 to the 27th fucking power that it happened. Stick that in your pipe and smoke it, Hank.
Your Honor, is asked if I could, please, if you could turn to Exhibit 2, which is entitled Digital Forensics Products Tools Used by Witnesses. And I just want to make sure Your Honor has that.
Do you have it? Look at him. He's loosening up. Did you see that?
So I prepared this demonstrative exhibit to show the tools that all parties used. And the purpose of this is to show how closely Mr. Green and Ms. Hyde match up with the tools used and how insufficient Mr. Whiffen and Mr. Garino are. So if you look at the left-hand column on Mr. Green, and I color-coded it to try to make it easier, you see 7 tools used by Mr. Green. You see 6 tools used by Ms. Hyde in May of 2023. Many of her tools exact same as Mr. Green. You see Mr. Whiffen, who used really 2 tools, but to be conservative, I listed them as 3 because they're just different versions of Celebrite Physical Analyzer. And then Mr. Garino, Trooper Garino, used 2 tools. But here's what's really important.
He had a 2-2.
Springs from this chart. Mr. Green did more, had a more encompassing and comprehensive review.
Yes, he did.
Than any of the witnesses here.
Say it louder for the people in the back.
Back to Exhibit 1, he did 2 more steps in his methodology than everyone else. So 1 through 5 of the methodology, everybody did. 6 is analyze overall user activity, artifacts.
Babes, basically speaking, he did what? He did AP calculus. and everybody else was in Algebra 1. Just saying.
Interest, timelines of interest, and anomalies such as deleted data. 7, reporting as appropriate pertinent artifacts, other artifacts. For this motion, Mr. Green did 6 and 7, and no other witness did that.
Mm.
The issue in this case as to whose interpretation is correct is an opinion issue. It is not a methodology issue. And Mr. Green makes that very, very clear in his affidavit that the difference is in.
Reminder, it is an opinion issue, not a methodology issue. Just like who, when he was fucking with our queen, Dr. Marie Russell, babes, okay? The same thing. How does she know how could she document or be able to determine if this was a canine bite or scratches, claw marks, or a mouth? I don't understand. If Hank is just effing with our souls, Hank is trolling us. Stop it. Hank is trolling us. And this is like not, this is not a trollable moment. This is not funny, Hank. No one else has the resources that the Commonwealth has. And what are we trying to do? Free Karens. Oh.
Opinions. Interestingly, on the very key subject of whether the artifact and the interpretation of it is a difference in methodology, a difference in application of methodology, or an opinion, which is not the subject of a Dalbert Lanigan hearing. Opinions are not. Here's what Mr. Whiffen had to say about the issue. This is Exhibit 2 to our opposition. It's the June 17, 2024 testimony of Mr. Whiffen, page 1.
Leah, very good point. She says Bev can't play, Judge Canoni can't play that she doesn't understand cell phone extraction when it's taught to every jury and involved in most cases. Today, yes, it is. Yes, absolutely. So, in my opinion, for her to say that there is no Daubert hearing that is needed, that is 100% guaranteeing that she is going to be letting Richard Green testify. And especially after seeing this impassioned argument by the assassin himself, Robert Alessi.
-10, starting on lines 14 to question. And what, if anything, did you find with regard to the web history artifacts? Answer, this is Mr. Whiffen. So the 22740 timestamp was correct insofar as that is the time that is shown within the database. It was indeed a deleted record. But the interesting thing was why the timestamp said 22740. And I did some testing on this and discovered the reason why 22740 was actually listed in the database, even though that's not the time. Here's the key, in my opinion.
Oh, here's the key. Did you hear that? Oh, he was talking to you, Judge Canoni. In my opinion.
That the search was conducted. So Mr. Green's opinion is, after applying the methodology that everybody agrees to, after using the same tools as every other witness for the Commonwealth used plus more, Mr. Green's opinion is, to a reasonable degree of scientific certainty, that that search and that record that everybody saw at the time of trial, at 22740, House Long to Die in the Cold, Mr. Green says it means what it says. The search occurred at that time. Now, the Commonwealth, in its recent reports, and they did this also at trial, they said, yeah, we see it, it's in there. Ms. Hyde said, I see it. It's not only in there in Celebrite Physical Analyzer. I used Axiom, just like Mr. Reed. Mr. Whiffen didn't use Axiom. Ms. Hyde said, and I'm going to point to it specifically, Axiom shows it as a 220, that search is a 224.
My God.
In fairness to trying to get the best decision for your honor here, they disagreed, Mr. Whiffen and Ms. Hyde, as to whether that meant the search actually occurred at 22740.
Yeah.
That's the opinion that's disputed. So in fairness to the issue and accuracy, those witnesses diverted at the end as to whether what that timestamp showed, 22740 a.m., did the search really occur then, or as the Commonwealth said that it did occur at 6:23 in the morning? Mr. Whiffen says it's a difference of opinion because he says it's my opinion. The Commonwealth in this motion tries to make it seem like it's an issue of fact. That Mr. Green doesn't have any fact. Well, Mr. Green's got a lot of facts. And he also, of course, has an opinion.
Oh, receipts, proof, timeline, everything. This is so dramatic. I want only Tamara Judge from Real Housewives of the OC of Orange County to go, it's my opinion. when she's talking to Vicky in like season 9. This is mind-boggling. And like we said earlier, babes, Hank Brennan has made the Commonwealth of Massachusetts the judge, jury, and executioner. And that is it. That their experts are experts and that they have all the facts. Well, babes, then what the fuck is a jury for? Because they're the what? Fact finders. Mic drop. I'm done. Good night. Thank you. Thank you for coming. Just kidding. Sorry. That was dramatic. I channeled Jimmy.
So what we have from these two demonstrative exhibits, Your Honor, is a statement of the methodology in Exhibit 1 that every witness agrees to. Not only is it Mr. Green put a methodology, but we prove up in the opposition that there's no dispute. What's interesting, Your Honor, and I think quite remarkable, is that neither Mr. Whiffen in his 40-plus page report of December 24, nor Ms. Hyde in her December 24 4-page report, neither one of them say Mr. Green's doesn't have a methodology. They don't say we dispute his methodology. It's the Commonwealth's attorneys that are making that dispute. And that is not appropriate. It's got to be your expert. And I think there's a reason why the experts of the Commonwealth are not talking about methodologies or saying there's a dispute, because it's objectively verifiable that there's not a dispute over the methodology. What is also important.
He's so good.
Is what has happened since the trial.
Yes, tell me.
Is give a baseline of the trial, because I think it underscores the two issues that Your Honor have in front of you: qualifications and methodology. And the qualifications, all I'm going to say about that is Mr. Green has 25 years of experience in computer forensics, and he has 18 years in digital forensics. And the 18 is only because digital forensics became a thing 18 years old. There can be no dispute, and I think that's why the Commonwealth didn't really say anything about it, is because if you lay down Mr. Green's experience next to Mr. Whiffen, Mr. Green testified 23 times as a qualified digital forensic expert in 7 different states.
Oh, let's just put that in our little caps, babe. 23 times he has testified as an expert witness in 7 different states. Thank you, Mr. Green.
Mr. Whiffen, he's testified in 2 states, one of which was here, and he does not have anywhere near the years of experience.
Ooh, and Ian Whiffen, who some of us, I don't know, that maybe live in a yellow cottage would tell us that he developed and made the Celebrite code, and he does this. And I think that the wicker furniture may or may not be causing some sort of just wooden calcification occurring in one's brain. We've got an expert with two appearances, one of which was at Commonwealth V Karen Read. And what was Ian Whiffen, in our opinion, most excited about? He was most excited about selling, like, and subscribe to Artie X, the One Man Party. Okay, his new app.
Here's another very important point: certifications. Mr. Green lists 3 certifications. He lists an enormous amount of constant updating. And I just want to state a point about digital forensic experts. They're not like medical doctors where you see people with PhDs, etc. These are folks that keep.
We love that. We just want to get to right where he says everything, because I want to make sure we get all this.
Forensic analysis that she used. It's the exact same methodology.
What are you? I thought you said Exhibit 4. Exhibit 4 is a transcript. It's a transcript of Ms. Hyde, but it's not a report.
Okay, my fault. We have different numbering, but I'll go to the transcript. I'm going to go to the transcript with regard to it. So
I'm happy to look at the report if that's what you're referencing.
No worries.
The Commonwealth is ignoring in its 2024 December report all the other tools. Even though those tools show this timestamp of 2/27/40 still, at that time, they now just ignore it and go to the Celebrite physical analyzer. That it's undisputed that Celebrite went back and changed it in the middle of the first trial with regard to one physical analyzer program. And then after the trial, the other physical analyzer program, they went and changed that and took it off. But in contrast, Axiom, that Ms. Hyde used before, still shows the timestamp. It's undisputed that that's the case. And it's undisputed, because they don't contest it, that Mr. Green went and looked at it in Belkasoff, Sanderson. He did a
Baltazar, Sanderson, the Axiom, he did it all. But here was the biggest thing, guys, is that the Commonwealth asked Jessica Hyde to go back, and that when she was only allowed that limited scope, and it was to go into the Celebrate, right? And the one other, the Axiom, where I believe it still lived. But we already had known that Celebrate had made an update. So you're asking somebody to look into data that had already been changed by the manufacturer for the newest updated version. What the that is so egregious. If you really think about that, you retained an expert that you paid $11,743 to, bitch. And you knew that one of the two programs she was going to use had already been updated. Clutch your pearls, clench your butts.
manual. He did a low-level analysis, and in every one of those tools, the timestamp still occurs. So now back to the transcript. Your Honor, I am looking at, the question of, and this is, again, a significant point, is it better to use more tools? It's common sense. That's what Mr. Green says. That's what Ms. Hyde did the first time, but now all of a sudden she's down to just one tool that unilaterally removed the timestamp. So here is the page of the transcript of what Ms. Hyde had to say. Page 1-13, Your Honor.
Okay.
Line 4, question, again, of Mr. Lally. Now, with reference to the tools that you use that you just went through, are those fairly common tools? Are those tools that are commonly used within your industry? Answer, yes. And what are those tools that she talks about above? Starts on page 1-2. Celebrate Physical Analyzer, Magnet Axiom, Artex, iLeap, and I later used Sanderson Forensic SQLite. Those are 4 of the tools that Mr. Green used, and he used more.
Yes.
So her answer is, now with reference to the tools, are those tools that are commonly used within your industry? Answer, yes. They are commonly used digital forensic tools that are very standard for other forensic examiners to use on mobile exploitation. It gets better for the defense. Next question, line 15. So different forensic tools, question, and why were you using the different tools? So different forensic tools have different capabilities and look at data a little bit differently. Skip down. Commercial forensic tools, that they can only support so many applications, so they each work and support different bits of data. Here's the key point, line 22. This is Ms. Hyde's words, under oath. So it's important to use multiple tools so you can see the results from different data sets, and be able to compare those results and enhance those with manual analysis. Next page. Question, and with respect to, and this will be the last question and answer, and with respect to using those sort of different variety of tools, Celebrite to Axiom to Artex, etc., is that something you typically do as far as your normal process of documenting a forensic analysis? Answer, yeah, that is very, very typical for me to process with multiple tools to ensure that I'm getting the most complete interpretations from forensic tools. Of course, you go beyond that with your analysis, but it's absolutely pertinent. And down below, he asked, can you explain the interplay of these tools in analysis? And her answer is strikingly the same as Mr. Green in his affidavit in our opposition. Her answer, the Sanderson's tool, which Mr. Green and Ms. Hyde used, but Mr. Whiffen didn't, is meant to look at specific type of data structures called the SQLite database. SQLite databases are very nuanced, and this particular tool allows you to take that database and explore it at a deeper level than the other forensic tools allow.
Oh, okay. So now that's assault. The Sanderson sisters are able to show you what, guys? The history of Salem. They've been there for 400 years, okay? It's 1682, all right? And you're able to go back and you're able to find everything from them, okay? Billy is a dead zombie somewhere. Let's go get him. And all we know is this, is that with the Sanderson sisters, that's how we're able to get all the way to 227, 40 seconds, and 423rd to the gigawatts, okay? It's insanity.
Mr. Whiffen didn't use the Sanderson tool.
Of course he didn't.
We have Ms. Hyde in her report,
Slytherin.
5/23, 2024, her first report, and I'm going to get to her report here, she basically goes through and documents this methodology, and she documents the use of those tools. And she also documents that she saw the House Long to Die timestamp 22740 in every single tool that she used. Where she diverted from Mr. Green was her opinion as to whether that timestamp meant the search occurred at that time or did it occur sometime later. That's an opinion issue again, and Mr. Whiffen agrees it's an opinion issue in that regard. So now let's come to where we are for this motion and what was submitted.
Where are we
by the Commonwealth.
today?
And I want to first go to the report of Ms. Hyde now. It's Exhibit 4 to the Commonwealth's motion. And it's entitled Digital Forensics Analysis Report.
Sure is.
And there's been much said in the Commonwealth's argument this morning about allegations made by Mr. Green, which are all supported. Every single one supported with facts. But what the Commonwealth didn't tell the court is what the request was of Ms. Hyde. I just went through all the tools she used, why she used them, why she said it's best practices, why you use all these tools. What does she do now in December of 2024 to assist in the myopic approach of the Commonwealth to say, here's our studies, we only look at Celebrite Physical Analyzer,
That's
and it's
all we
gone. The
do.
search is gone, right? And we know why it's gone, because Celebrite, Mr. Whiffen, concedes that he went back and talked to the researchers, and what we have, Your Honor, is a total black box. And I'm going to point it out in a moment. Why is this no longer appearing on Celebrite Physical Analyzer? We don't know the answer. All that is stated is a bold conclusory statement that it's no longer reliable. That's it. We don't know why it's no longer reliable, but we know.
I do want to remind you all, babes, I don't know if you remember this, but Ian Whiffen testified that this is so rare what had happened, right? This 227 time search. And it ended up working in the favor of a defendant in Austria about 6 months after Officer John O'Keefe, after his death in January of 2022. So in the history of Celebrite, there has been Jennifer fucking McCabe and an Austrian that has actually made these. It's so rare. I mean, bitch, like, no offense, pardon me, but God forgive me. Go play the lottery. If you are telling me that this did not happen, but you and one innocent Austrian, who the defense was able to be like, in that case, it worked out for them to prove that they weren't somewhere. And now they've had to change their entire software to update it for, I mean, did they call it the McCabe code? What are we doing?
Oh, it's gone. And Mr. Whiffen never says, even though it's gone in one, he doesn't even address the other 4 or 5 tools where it still appears. It still appears. Now to Ms. Hyde. Disquietingly, on page 3, look at the request, please. The request was to understand changes made in newer versions of Celebrite Physical Analyzer to artifacts pertaining to the timeline of a Google search on January 29, 2022, namely House Long to Die in Cold. That is stunning. The request to her was simply to look at one tool that everybody knew by then Celebrite had deleted in their program. She then looks at evidence analyzed, second paragraph. This full file system image was processed with Celebrite Physical Analyzer, version blah, 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 decoding engine, etc.
Visitor, okay, yep. You're so good.
There's no need for a hearing because there's no disagreement on.
I got to go back. That's the one part. Sorry, damn it. Okay, listen to me. Is there nothing that is more attractive or like, do I not feel like I'm in a storyteller's presence? He is me. I am him. A man or woman that uses their hands when they're speaking is my family. I might be related to him. Is he my third cousin? I don't know. Here it is.
Last visit timestamp. So here she did a manual analysis and it still shows up, but she doesn't explain the significance of that. If we want to talk about reliability, Your Honor, the real question should be the reliability of the prosecution's witnesses in Celebrite Physical Analyzer.
So you're telling me that we should have a hearing?
Your Honor, there's no need to have a hearing, and here's why. There's no need for a hearing because there's no disagreement on the Daubert issues. The dispute over what is the interpretation of this data, what are the people's opinions, is never one for Daubert. If that were the case, there'd be a Daubert hearing on every expert because experts, almost by definition, on each.
And that is how he shuts it down. If there was a need for this, we would have a Daubert hearing on every single expert witness ever. And that is where, in my opinion, Judge Canoni took her glasses off. I can just picture her, okay? I'll have to ask Esty if this was happening. And was she swinging them? Was she swinging them like she does? Because she was like, fuck, I actually need to rule in favor of this for the defense.
Side disagree on the opinions. We don't need a hearing, Your Honor, because they agree on the methodology. They agree that more tools are better. They agree that the difference is at the very end of the analysis, which is the opinion. So in terms of the issues with regard to Mr. Green's report, which is my final point to get to, there's been so many mischaracterizations by the Commonwealth this morning of what Mr. Green did and what he said. So what does he do? He says, and Your Honor, digital forensic analysts are the equivalent of a medical examiner. Their job is to look at, to apply the methodology that is agreed to. Their job is to use the tools, everybody agrees on it, and then they're to give opinions on what those mean.
Yes. Now, we're not going to listen to Hank because Hank is rude and he doesn't say anything that's cool. But we do hear this is the final. This is the good old finish him by Alessi. Oh, clutch your pearls.
So there is a real accuracy on thousands that Mr. Green promotes in this case. And so we're happy to do it. We welcome it.
Okay. Did you want to say anything very briefly, Mr. Alessi?
In 60 seconds or less, Your Honor.
Okay.
Thank you for the opportunity. The Commonwealth said a little knowledge.
First and foremost, we did not acknowledge. Look at Bev's hair. She had just seen Teresa down in Newton, okay? That's who does her hair. I like a lob. She cut it off. We're a little shorter. We're in our winter blonde. I like it, Beverly, okay? I like that you took my opinion. And it's my opinion that a coral is not your red. I like your look.
Which is dangerous. I don't know what a hashtag is. I've never heard of what was just said as a hashtag.
I just want you to take a moment, babes. I want you to gander at the face of our king, of our handsome, dimpled king, named David. I believe his middle name is Patrick. Now he is because I've named him. I have named you from here on, and today you are David Patrick Yannetti. And these dimps are dimping so hard after that Hank Brennan kept referring to a hashtag, okay? Like hashtag free Karen Read. But what does Mr. Alessi hit him with?
The Commonwealth said a little knowledge is dangerous. I don't know what a hashtag is. I've never heard of what was just said as a hashtag. It's a hash value, and it's a very important concept to get.
Look at our babe. Look at Mr. Yannetti. He goes, bitch. It was a moment. He was like, you got him. You got him. Look at you. And I got a hashtag for you. All right. Mr. Alessi, are we fucking hashtag? All right. 2025. What are we doing? Because this was everything. I'm obsessed.
Right. With regard to the whole premise and point of my argument, Your Honor, that this is a difference of opinions, it was just made by the Commonwealth Forum.
It was just made for him. Beautiful. And now I want you to hear, this is the final words of our judge, and who wishes she was still knee deep in clams down the Cape, but she's not, babe.
An evidentiary hearing on that, but I expect it will take time. All right, so the Commonwealth will have all of its discovery to you, it expects, by Wednesday the 5th.
Beautiful.
That's correct.
Okay. We'll be back here at the end of next week.
Wait, did she say it before or after?
Motion. What I need to know before I hear the motion, on the expert-related expenses is what sort of protocol you all worked out.
Oh yeah, and they denounced or not denounced, Jesus Kim. Hank doesn't want to pay the defense for the expert that came up for
I believe there's a
nothing.
footnote that highlights a pending motion to dismiss. I need that motion to dismiss. We need to get this moving. When will that? Well, I'd like that filed next week so we can hear.
Oh, and by the by, babes, before we end this, I just wanted to say Judge Cannoni is like, when we see her ruling in the same day, we know damn right well that like she will not allow this to be put out any further unless this does get, unless the motion to dismiss goes through and is approved, which it is not going to be. We are on track for April 1st. April Fool's Day will be Commonwealth V Karen Read. Judge Cannoni is not messing around. And she is like, let's go. Green means go, boys.
Hear it next week.
The reason that we haven't finalized it.
Oh, no, I don't know where she said that, but
Yes. I just want to get a scheduling order going, so I need some of these.
Long
dates.
story short, though, babes, she said specifically in the clip, and sorry, I apologize, but she says that it is 100% that she's going to go through everything, bop-a-da-beep, bop-ba. They're discussing the scheduling. And then she says, I believe this is an opinion matter. So she acknowledges that this is an opinion-based concern and that she ruled that there does not need to be a Daubert, leads me to believe there is no way that Judge Beverly Cannoni would allow some Richard Green to testify in trial 1 and not allow him to testify in trial 2, specifically where the findings and the new affidavits that have come out are only more favorable to the defense than it was in the first trial. So, she put it out, said we do not need that. We do not need a hearing for it. And I believe that we will probably on Monday get her, denial completely of their motion from the Commonwealth of the debunked theory. Oh, with that being said, I have to go, babes, because I have a space with Larry Legend, but I wanted to say to all these beautiful no human beings, hi, Alabama's Amy. You are a lovey, and I love your picture. Hi, Jerry Garcia. Thank you for becoming a member. My petty paralegal. That's my sister. Okay. Mom, were you in the chat? Mary Malaki, please stand up. I know, Petty, it's been hard for you as my mother's second favorite daughter, but I appreciate your support and kindness. My family has come through for me this week. And Petty Paralegal, thank you, Lovey, for donating. Yes, you donated 5 Nurse Kim non-consensual memberships. And to Mariah Cheyenne, where have you been? Mariah, I haven't seen you since like Christmas. We were at Centerfolds in Worcester. I love it. And Random Girl gave $5 to Nurse Kim and said, I'm so ready to hear you and Attorney Nan speak about medical aspects of this case. I am so ready too. Her as a medical attorney, like I am so excited to see her opinions and to see and to just pick her brain. I also am obsessed with her teal office, okay? I've got Hank's pencils behind me, and she's living in a teal office with a chaise lounge. Invite me over, Nan. And then we have Deborah Coons who said, okay. Oh, I wanted to pull this up. She said, okay, Krusty also put a mugshot of Green. I wanted to go through my tablet after her. How dare you? Her and Plevin are so gross. Yes, that is accurate, babes. And I did want to say to you guys that was dismissed. Okay. I know that there was a charge, but it was dismissed. Okay. It wasn't quaffed. It was dismissed completely. And I think that it is so sad that we have gotten to a place that like none of these experts have been even suggested that there is a crime that they have allegedly committed. They weren't witnesses to anything. These are just experts. These are professionals who have put their opinions on something in a case. They messed with Dr. Marie Russell and a civil litigation that she went through because of workplace discrimination. I mean, is there no low? Like, I don't know, and I'm not saying that it's not true, but I haven't seen anyone that would be considered on the free Karen Read side that has gone after and looked for like the criminal or civil litigation history of any expert that is on the Commonwealth side. That's gross. Do better. Be better, people in the world. Like, be better to each other. I know that we have passion in our hearts about, our stance, and we believe firmly what we believe. But I don't want humanity to be gone and for there to be lines that are crossed that are fucking habitually overstepped, in my opinion. Like, we can think what we want, but let's leave it where it is and not try to harm people. Like, just be good humans. That's it. And I know that you all are. Listen, I'm just saying I'm saying to the internet, to the hate watchers, try to be good. Be good. You will be rewarded with goodness. Just try to put out what you want back, man. All right, babes, I'm going to be going live with the one, the only Larry Legend at 9:20 p.m. We're going to have some fun. We're going to get a little sassy and fresh on the spaces and just have a little decompression with each other. So I thought this was a great hearing. I think this is a great day for the defense and for the Free Karen Read movement, for us to be moving in the right direction. And we have 2 court dates next week, Thursday, Friday. I love your faces. Thank you for joining me. I know it's been a week, and I appreciate every single one of you. I love you guys. Talk to you soon. Bye.